Welcome to a Point and Lemonade webinar. Point and Lemonade provides your essential dose of legal knowledge. Point and Lemonade aims to make general legal knowledge and information easily accessible to the average South African citizen. Please note that all the information shared during this webinar and generally by Point and Lemonade and through all Point and Lemonade platforms is shared as legal knowledge only and is not to be construed as legal advice. Thank you for attending this presentation. Please follow us on YouTube, Instagram, LinkedIn, and Facebook.
Do you ever wonder what will happen to your belongings when you're no longer alive? That is, when you're dead? My name is Mbonisi Ndlovu, and in the next series of videos, I will be discussing the laws around making wills and actually dying without one. I will be discussing this under the topic Wills and Estates. So there's various topics that we'll actually cover under this specific topic of wills and estate. Amongst others, we will be discussing what is a will, who can have a will, who can make a will, the requirements of actually having a valid will, who can benefit where there's no will, and the different types of wills, and finally discuss how to actually amend a will when you have one in place. So, what is a will? Simplistically speaking, a will is a written document with important wishes of a will maker, leaving all assets to the beneficiaries, while keeping all legal requirements and making sure that they're complied with. So the long and short of it is that a will is actually not a contract. It is a legally binding document upon yourself and only comes into effect when you are dead. That basically means that if your beneficiaries discover that you have a will in place and they see that they're actually beneficiaries, they can never say, "Mommy has given me this specific asset and therefore this asset is now mine because it is written in this document." It is not a donation. It is a tool that is used by yourself to actually ensure that all your assets are distributed according to your wishes when you are no longer around. Now that we understand what a will is, the second question to ask is, why have a will? There are various factors that you can actually consider as to why should I have a will as opposed to dying without one. Number one, you can decide as to who can actually inherit in your estate. What you've accumulated over the years, you get to decide who gets what. Secondly, you get to actually avoid disputes upon your death amongst your relatives. So nobody will come at your death, at your funeral and say, because this was my nephew or niece or whatever, I am entitled to this jacket or whatever, I'm entitled to this car because of the fact that we're blood related. In this instance, you dictate exactly how you want your things to be distributed. Thirdly, you get to create a trust. If you're currently married or perhaps have children and the children are quite minor, you get to create this legal entity or perhaps this tool that allows your children to actually have your assets to be protected up until the time where they actually are old enough to actually handle the funds or perhaps whatever assets that you would like to leave for them. So essentially, you're just leaving a guardian in a sense to protect your assets upon your death up until they get to a certain age, which is quite an interesting and useful tool to actually incorporate a trust in a will, especially when you've got children. And the fourth thing is that you control who your executor is or are. Basically, what that means is that upon your death, you're no longer around. Literally, somebody has to come in your stead and distribute your assets and say, according to the will maker, yourself, you wanted your things to be distributed in this fashion. Now, the executor will then take that role of actually taking your assets, having the power and control of actually distributing it up until that whole administration of your estate is completed. Furthermore, it's also planning for future circumstances, because, the future is often uncertain, especially now with this whole COVID. You decide what will happen to your assets. Now, what are the requirements of having a valid will? Number one, it must be in writing. So pen on paper, or perhaps can be printed. So essentially, it has to be in a physical form where it's an actual document that can be read, essentially. And every page of the will must be signed or initialed by the testator anywhere on the page. So what is a testator? A testator is another fancy term to say will maker. So the will maker or the testator must sign the will at the end, or perhaps at the last page of the will, and have two witnesses in the presence of two witnesses, and ensure that these two witnesses also sign the will. So the two witnesses have to be 16 years and older, they have to be of sound mind, and they actually have to be aware of what is happening and not like senile or crazy, right? And the witnesses themselves, exactly that, they have to sign. There's this myth that goes around that says that you must have a lawyer draft your will. So as you can see, there's 4 simple requirements. None of them say that a lawyer has to draft your will and that that document has to go to the police station to be certified, or perhaps it has to go to some institution to actually be authenticated. None of that. So essentially what I'm saying to you is that you as the will maker have the power to actually sit down, write your will according to your own terms, whichever fashion. There's specific clauses that you would obviously want to have in your thing, which a lawyer will be privy to. However, a will could simply be a 2-liner to say, I leave all my assets to my child, and the distribution of my assets will be controlled by a specific person or whatever. So it could literally be that. So you don't need a lawyer to actually do that for you, but it will be very advisable to actually have a lawyer draft one for you, to have all the necessary clauses in there. So you don't need any other person to actually authenticate it, because at the end of the day, a will is a document that expresses the will maker's wishes. Now that we understand what are the requirements, or perhaps of a valid will, let us look into who can actually make a will, right? So any person who is older than 16 years old, right? And secondly, you must have a sound mind, as in like you're not senile, you're not crazy, you are of a sound mind, right? So what this means is that if the only thing that I currently own in this earth is just a piece of clothing, you are entitled to actually draw up a will. So essentially, if you own anything, even if it's a pen or perhaps whatever that you own, you are entitled to actually draw up a will. However, the most important thing that you should take into consideration, you can't draft a will with another person's assets or perhaps belongings in your document, because a will is an expression of what you would like, or how would you would like your assets to be distributed upon your death, right? So if your parent promised to give you a car, you can't have that on your will because it doesn't belong to you as yet. However, if it's already yours and it's in your name, then absolutely you can drop a will and say, I would like all my assets to be distributed in this fashion. So if you own anything, you can absolutely drop a will. So because at the end of the day, it's an expression of what you would like, or how you would like your assets to be distributed when you are no more. I hope this session was quite helpful. If you do have any questions regarding wills, please drop them off on our email, that is pointinlemonade@gmail.com, or perhaps just drop us a comment there on the comment section. Please click like and subscribe, and also share this video. It can help somebody. And if you do have any myths or perhaps questions that you would like us to clarify, by all means, we'll be happy to engage. We'll be sending out another video in the next couple of days, and we'll address other aspects of having a will and what having a will means, or perhaps how your assets will be distributed should you not have a will in place. Thank you for joining us, and we hope to see you again next time.